we're covering debt restructuring, identifying the issues and early planning. And our guest speaker today is Gary Beastie, who is one of the 4 founding partners of South Asia Law. He delivers strategic advice on commercial matters, corporate issues, and finance, both domestic and international clients. Prior to founding South Asia Law, Gary spent 27 years with the global firm JSM Mayer Brown, where latterly he was managing South Asia. His industry experience includes hotel and leisure, banking and restructuring, real estate and development, and manufacturing. For 17 years, Gary represented the government as the honorary consul to the Royal Thai government, and Gary has also served on the BCCT board of directors on 2 separate. Gary won't be using slides, but he has a paper that he will give to our website for you to access after the webinar. As with all our webinars, please post your questions using either Q&A or chat at the foot of your Zoom screens during the presentation, and we'll come to those.
And to that extent, I believe most of you may well have already considered what we're going to touch upon. However, I thought it'd be useful that we try and bring the issues together in a kind of a sequential order and allow us to share the concerns that we may have. So it's not exactly a problem shared, it's a problem halved, but I think in these difficult times, it's good to know that you're not alone as a manager. And there's also a natural reluctance, I think, by anybody, quite natural, to not make public private concerns that you may have as a manager for fear of worsening the situation if you appear vulnerable in the marketplace. And these concerns typically we find are, as I say, they're not legal. They tend to be more managerial, more economic, more concerns. And so there's generally an underlying concern about the future at the moment. That very much is compounded by the Thai economy, which has been suffering for some time, and of course further compounded by COVID. And so in that situation, we all tend to look at what our customer or consumer demands may be, and we begin to reflect on the viability of our businesses over time. We then start looking at our assets, and our assets may be employees, they may be machinery, and we start looking about whether we're going to be using those, utilizing them sufficiently, and indeed, are we realizing the benefits of those assets? So utilization, realization, from that realization comes profitability. And then finally, which probably comes first, is liquidity. And I think that's where we find clients come to us for the first time when they begin to realize possible liquidity issues. And may I emphasize that these considerations, they apply as much to any SME as they do to a publicly listed company, or indeed a multinational. A threatened future loss of liquidity is just as serious if you're looking at a 10 million baht problem as if you're looking at 100 million or 100 billion baht. I suppose the only difference is that larger enterprises have a potential to hold off the day of reckoning a little longer because they tend to enjoy greater banking support. But the personal and corporate impact of bankruptcy and liquidation is no more severe in any situation. I'll just hesitate for a moment and just distinguish between bankruptcy and insolvency. Many of you will associate bankruptcy as a personal thing, insolvency as a corporate situation. But in Thailand, the term bankruptcy encapsulates both personal and corporate. So that's why we talk about bankruptcy rather than touching upon insolvency. So by way of background, many of our businesses have been suffering from the economic downturns in Thailand for the last 2 years or so, or maybe even a little longer. Those economic conditions have been exacerbated by the pandemic. Of course, there's a few sectors that have flourished, and good luck to those guys in logistics, IT, healthcare. But most areas of the economy have suffered and continue to suffer. And some of it face very uncertain times, notably food and beverage, tourism, ancillary, the airlines, the list goes on and on. A lot of people wonder why the banks have not begun to push harder about underperforming or even bad debts. And I think it's worth making a comparison about what is happening today and what happened in 1997. Many of you will have experienced the Asian crisis of 97, which was initially, it identified itself with the collapse of the Thai baht. And in 1997, because many of the central banks of the various Asian nations were supported by the IMF, they were bailed out. The IMF required these banks to identify debts from enterprises that had become doubtful or bad. And the effect of that was it required the banks to pursue recovery of the debt. That proactive interaction between the banks and their debtors forced the debtors to seek an arrangement. And if they didn't seek an arrangement with the banks, they would face either controlled rehabilitation or bankruptcy. More of that a little later. Indeed, just to put that in perspective, at that time, following the 97 crisis, my own firm, as there was then, we were involved alone in Thailand in over $10 billion of restructurings. So the impact of that particular crisis can't be overstated. And then we had the subsequent crisis, which was more of a global nature in 2008. Thailand didn't suffer so badly in 2008 because it was in the process of reorganization following 97. But what happened was that the G20 nations, the central banks of those nations, they put together a protocol which was called the Basel. The meeting was in Basel. And the latest iteration of that is Basel III. There is a Basel IV, but basically this is a protocol which determines how domestic banks should book their debts and identify the bank's own liquidity. So the bank has to prove its own viability by booking the nature and the extent of the debt that it carries from its debtors. Too much debt on the balance sheet of a bank weakens the bank's capital adequacy and therefore makes the bank itself vulnerable. So since 2019, myself and many of the restructuring professionals, probably some of whom may be on this call, we were expecting a similar dynamic to that occurred in 1989. We thought that the banks would be pressing for the debtors to perform. But what happened was that the Thai central bank, which originally had instructed Thai domestic banks to follow Basel III and be aggressive with their debtors, the Thai central bank, they actually instructed domestic banks not so much to follow Basel III, but to encourage them to negotiate and informally restructure with their debtors. And the Bank of Thailand has encouraged the banks to, where possible, record the debts as performing. The knock-on effect of this is that the debts have not been crystallized, and the banks are not taking recovery action. What has happened is that, to an extent, this has given some company managers an artificial confidence that they can trade through this current crisis. And I see this as a critical misperception. The fact that your bank is not pressing you at the moment doesn't mean that they will not press. And when they decide to press, things will move relatively quickly. It is a truism that reaction times are short. And as some of you may know, Ernest Hemingway was made personally bankrupt. And when asked, Mr. Hemingway, how did you go bankrupt? His response was gradually and then suddenly. So where does that leave us? We recognize that many debts are not being properly serviced. We recognize the banks are not yet pressing, but we do know that there will come a point at which the Thai government, to an extent pressed by international protocols, Basel III, they will press for the banks to begin to restructure. And then there'll be a substantial movement of debt from performing to non-performing, doubtful, or indeed bad. Now, earlier on, I mentioned that there's a kind of a chronology and a sequential order that clients, companies find themselves in. And that chronology begins, and that's the purpose of the conversation today, with informal, self-control, self-restructuring. The next step after that, which can be driven by the company themselves, by our clients, or by the creditors, is to be forced into a court-controlled, court-protected rehabilitation. And then in that sequential order, the final situation is if a company and its business, the viability is in question, then you can look at bankruptcy, which means that the business will end, assets will be realized, and creditors paid off as best they can. So I suppose the message today that I want to really emphasize is that prudent managers, they plan. And before you get to that court-appointed rehabilitation, before you get to that situation of bankruptcy, we recommend that you plan. In assessing your plan, we see the following points as essential. You're going to...
Gary, we've lost your audio. Gary, we lost your audio for a second from in assessing your plan. Yeah, we've lost you, Gary. Do you want to try logging out, logging? Oh, you're back.
Hello? Testing, testing.
Yeah, we've got the audio back, Gary. We lost you from in assessing your plan.
Very good. Sorry about that, folks. So I was talking about prudent managers planning. I think the first step is that we need to make an honest appraisal of our financial situation. That means assessing, in essence, the reality. How many months cash reserves do we have? How long can we persevere and hold on? in any given downturn. That gives us a strength and knowledge on how to deal with our creditors, the banks, our suppliers. It also allows us to realize and manage our relationship with our customers and clients. Critically, at this point within our plan, we should assess our workforce capacity and our relationship with our employees. I hesitate at this point simply to say we could make a complete webinar just on how to manage the workforce situation, because in reality, the two most expensive items that most of us as enterprises have is the cost of our workforce and the cost of our premises. And the assessment of our potential liability in this sequential restructuring, rehabilitation, bankruptcy, the assessment of our viability in the long term is very much driven by the cost of our employees, and very, very importantly, the cost of compensating the employees in the event that they are released, either voluntarily or it becomes compulsorily. As I mentioned, dealing with the landlords is also vitally important in this. And if, having made that honest appraisal of our financial situation, we don't have the cash reserves, we have to start reviewing whether or not we can raise additional capital to see us through these difficult times. And that capital could be by way of shareholder loan. It could come from directors pursuing external investment, or indeed going back to the lenders of first recourse, the banks, and persuading them that potential for them to be repaid in the medium to long term is dependent upon them giving us some short-term ongoing support. Conducting that honest appraisal of our financial situation also means the very difficult but very important review of whether it's a strategic time to dispose of part or all of our business. And all of this is about planning to transition from a company or an enterprise in uncertainty, in uncharted waters, into one that knows the depth of the problem, but has an understanding of the way to move forward. Now, one of the advantages of conducting this informal plan is that should your creditors begin to force you towards that next sequential stage, which would be rehabilitation, should your creditors begin to force you, you've begun to prepare a plan. Some of you will be aware that if you seek court rehabilitation, if you seek the protection of the court by way of a petition, you have to submit a formal plan. I've been talking about informal plans, but when you apply for the petition to have a rehabilitation, it's vital you have a clear formal plan. And Greg, you might touch on this when we're wrapping up. There is a plan that there will be all plans. It is, the BCCT intends to have 2 further webinars touching on the formal rehabilitation and the preparation of the formal plan. But my point today is that the informal appraisal of your situation can assist you in transitioning into the formal rehabilitation necessary. And it's worth just dwelling upon the constituent parts of that rehabilitation plan which goes to the courts. And those, actually, they address very much the points that I've been mentioning today, which is that the plan must include the background of the debtor. It must explain the cause, the failure for the failure to pay debts. It must dwell upon the rationale for rehabilitation. What's the viability? Can the enterprise emerge out of rehabilitation? There has to be a summary of the debts, the assets, liabilities, the creditors, and the classification of creditors. You'll be aware that some creditors are preferred and some are unsecured. There are other items on this formal plan which we don't need to dwell upon today, which include who would be the administrator. If you were to do a voluntary rehabilitation and bring yourself to the court, oftentimes the directors would be their own plan administrators. Conversely, if you're forced by creditors into a compulsory rehabilitation, then they would appoint their own plan administrator. And there would be a timeline for the plan, which says, this is where we think the company is today, and this is where we think it can be in 3 years or whatever, by which time it'll be fully rehabilitated. So in that formal protected rehabilitation, the company will hopefully emerge out and prosper. But if any of the stakeholders of the enterprise form a belief that there's no viability in the long term for the company, then there's a real possibility that the company will slip into liquidation or bankruptcy. So every effort should be made, I think, to avoid falling into that, which is why the essence of this presentation today is that you should now address these issues before they become forced upon you, which can happen with alarming speed. So in reading my conclusion, in finishing, I would simply reiterate that a prudent manager should already be carefully and regularly monitoring the situation. Anticipating future needs is crucial, and it'll be far easier to manage the future if, before matters become crucial and critical, there's an outline plan reviewing the long-term viability of your business and the means of surviving and thriving in the fullness of time. To mix an idiom, our law firm, we today act as gamekeeper turned poacher. Historically, we've acted for lenders, and we've been the ones driving the businesses to make hard decisions. Today, we see our role as helping companies make those initial hard decisions for themselves and not have them forced upon by external third parties. I finished a little early there, Greg, but not too much under the 30 minutes. So I thought I would leave it open for any questions and answers.
Fantastic. Thanks, Gary. Yeah, we're in good shape. Ladies and gents, if you'd like to pose a question, please do so in Q&A. We have one to kick off with from John Anderson. Any comment on the DPA's recent bank deposit protection cut to 1 million baht from 5 million baht from 11th August onwards?
I'm going to be very candid, John. I don't, 11th of August, maybe, John, you could come in and help us on that and we can debate, we can discuss it.
Okay, while John's coming back, does anyone else have any questions?
I will speculate that it's just obviously in the nature of making it easier to move forward in a more formal way. But I'm afraid that I wasn't aware of that development.
Okay, just to allow a little bit longer for a question to come in, Gary mentioned 2 future webinars that we'll be having on debt restructuring, different aspects of it. On 2nd of September, we'll be looking at the court process, so through the court, the basics. And on the 30th of September, we'll be delving much deeper into the plan and what it should include.
I think, Greg, I think,
go ahead, Gary.
So I rattled through what was a fairly, it can be a complex subject. I'm just reading from John, it was just reported in the Nation. John, I'll have to come back to you and we can look at that on another occasion. But the point, what's driven me to make this presentation today is not something that I personally believe, although I have to say that the legal business has been as affected as many other service industries. And so this is a reflection of many of my own considerations. But a lot of this has been driven by clients coming to us and saying, I'm concerned that my lack of liquidity is going to force me into the hands of my creditors. And once you're in the hands of your creditors, your destination or your destiny is outside of your own hands. And historically, this was driven by the banks, but right now they're not doing that. But I believe that we should be aware that day will come and we should prepare for it. It's not going to go away. And unfortunately, there's no immediate sign for most economic sectors of the economy recovering.
Okay, I think we've blasted them. No more questions, just John Anderson's comment. Anyone else, any comments or thoughts, last comments or thoughts before we let Gary go? Oh, hold on, there we go. Mr. Pascoe, welcome back to Thailand. Do you feel the current bankruptcy legislation allows a plan preparer to effectively and quickly restructure the debtor, given the lengthy court delays that can be incurred?
The short answer would be no. Inevitably, if we get into a court-controlled rehabilitation, there will be delays, and that will hamper the ability of the plan administrator to rehabilitate the company. So Mr. Pascoe identifies an issue within that formal process. I suppose what I'd respond, or what I'd add on to that, is that reinforces the importance of doing it informally and reaching out to the likes of Mr. Pascoe and looking for some assistance on an informal level to transition, if necessary, into a formal rehabilitation. But properly managed, the informal process can be faster and more effective.
Excellent. We have another. Oh, no, that's it. I think, Gary, I think we're done.
Okay, well, that either means it was a comprehensive presentation, or it was lacking in any substance. If anybody wants, if anybody wants to follow up with any questions through Greg, I'd be happy to manage them. Sure,
fantastic. Okay, I think huge thanks to you, Gary. You will send over the presentation, and as I mentioned at the outset, we will post that so you can have access. Other than that, thanks again, and thank you to everyone for joining us today. And please do try and join us on the 2nd and 30th of September for the subsequent webinars on debt restructuring. So fantastic. Thank you to everyone, and stay safe.
Likewise. Goodbye.
Bye-bye all.
Bye-bye.